Now, turning to the issue of upliftment of bar, which accused number one spoke to about.
Corporate value.
Corporate veil, yes. I see it. Corporate veil. Now, this court, I don't know, in its ruling on the discharge of discharge in terms of section 198 subsection 3, it also touched on this issue on this topic, the uplifting of veil. In that concept does not exist in criminal law. It is a civil law concept. And I also noted that my lady colleagues, the cases that they cited therein, they are civil matters, not criminal matters. There were no criminal matters which were cited, or any authority to suggest that the lifting of a veil is applicable in criminal law. It doesn't exist at all, and therefore the whole argument which was presented by the first accused person, which was also brought by the second accused person, that the two accused persons were not criminally liable in the absence of the veil being lifted, does not apply. So it is the state's submission that the evidence which was adduced by the state on listening to all the evidence which was laid by the Honorable Court through the audio tapes before which were in relation to the evidence that was adduced before the court. One would assume that there were certain areas, my lord, that my learned colleague thought that those were the most important salient points during the trial, without taking other issues which were said by witnesses. For example, there was an issue of a meeting which was held where there were minutes. But witnesses, on listening to what they have to say, like Obed Jiri, Menduru, and so forth, if one has to listen attentively to the audios or the meetings that were being carried out, it was not a single meeting, but the accused persons chose to elect only one particular meeting. But there is no law which says all meetings that should be held, they are supposed to be minuted. The mere fact that the agriculture officials say they met the accused persons on several instances, which fact was corroborated by the accused number one, who told this court that there were a lot of meetings which were held. It's a clear testimony that indeed such meetings occurred. And whether the state witnesses are going to be believed or not, it is a question of reliability and credibility of the witnesses. It does not follow that the happenings of such meetings are dependent upon minutes. It's a question of credibility. But in this case, their credibility was unscathed in that they were not challenged. The main challenge that was done was a demand for minutes, as if that is a requirement at law, which is not. All the witnesses were very credible witnesses. The state witnesses, they were very credible witnesses. They had no reason to lie against the accused persons, and they were not challenged. It was not enough to merely say, where are the minutes? It does not, if the minutes are not there, it does not necessarily follow that the minutes did not happen, unless it was a requirement of the law that such meetings were supposed to be minuted, yes. But there was no reference to such law that would require such meetings to be minuted. Yes. So Mr. Obedjiri was very, very detailed in the meetings that happened. Mr. Alban Mindurwa was very detailed. These were very witnesses who had nothing to lie against the accused persons. Yes. My Lord and Honorable Assessors, it is the state's submission that the accused person's argument was that this was a contractual issue. But the crux of the state's case was that there was the two certificates from NASA and Zimra which had been forged. That was common cause that they were forged, or at least it was not challenged in a material way. The first accused person's view was that he was not the one who had forged. The procurement of such certificates was as a result of a third party, which third party they had not divulged from the beginning. Now, given that it was a forgery, the issue of the contract having been valid does not arise. It was surprising during the trial that the accused persons would not challenge that those certificates were forgeries. Then surprisingly, they would also say the contract was valid. These two, the arguments, they were mutually destructive, because they cannot say yes, the two certificates were forged and therefore Black Deck was not eligible to tender a valid bid, and then they go on to say no, the contract was valid. That cannot happen. I think my legal colleagues, they should have been properly articulated why they would say it was a contractual issue, in view of the fact that it was not in dispute that the company had no right to bid because of the forged documents. Now, all the evidence that was led by the accused person on that, my lord, at law, it does not it cannot be said to be enough to persuade this honorable court that the contract was still valid. Here the crux of the matter that has been presented by the state is that the company had no legal right to bid in the absence of two documents. It's clear, it is not a dispute that the mere fact that the document, those critical documents were not there, the agreement was void ab initio. If it was void ab initio, then that is the end of the matter. Both accused persons, or in particular accused number one, never argued that his company was entitled to have those documents. So clearly he knew that those documents were forged. Because if he did not know, if he could not argue that his company was entitled to those certificates, naturally it means that he knew. Well, evidence was clearly adduced before this honorable court to the effect that his Black Deck Private Limited had his registration. This company was deregistered on the 8th of January 2016. And from the year 2016, it never registered. That was not challenged when the NASA officer was here. So for him to then say, no, he thought that his company was entitled to have such certificates. No attempt was even made to the two witnesses from Zimra and NASA to the effect that, no, our company was entitled. And this trial is happening over almost a year and a half after the arrest. If at all they were entitled to have those certificates, and if at all they were paying for the Jews, as the first accused person said, they would have availed such proof of payment, either to this court or in cross-examining the two witnesses from Zimra and NASA. But that did not happen. So therefore, he knew. And such knowledge, my lord, will tend to corroborate why then a non-existent company was then used in signing the contract between the government of Zimbabwe, and it was a clearly calculated move. It was not out of ignorance, but a well calculated a move with a criminal intent, that if anything had happened, that company was not going to be found, because it was not a legal persona. It had no right to sue or be sued. It had no directors. There is no company called Black Deck Livestock and Poultry Farming. That is the end of the story. In terms of Section 29 of companies and other business entities, my lord, chapter 24.31, my lord, it is clear that from January 2020, trade names were supposed to be registered. What the state does not really understand is an argument by my learned colleagues to the effect that that name, although it was not registered, it does not matter. I don't know whether it is a strict interpretation of the law, and if so, where they are getting that from. That was never said.
I think what the point is that it was perhaps just an omission to comply with the law. Would that really amount to intending to deceive? What I'm saying is that I heard the first accused person to be saying, at all times when they used the name black tech, is it livestock and poultry farming,
Yes,
or Colenso farm?
yes,
Their state of mind, at least his,
yes,
was that he's referring to Black Tech Private Limited. So
yes.
there was no, it may have been, there may have been non-compliance with that new requirement,
Yes.
but he said he didn't realize that they would be making misrepresentation. So there was no intention to misrepresent. And in any event, the people that they dealt with understood that all names refer to the same person.
My Lord,
To the same entity.
yes. My Lord, that is not the end of the story. The next story is that there was also Colenso farm being used as a trade name. Here, Section 29 says a company can only use one name as a trade name. But these arguments are being perpetuated by the by accused person through his lawyers in order to persuade the court. Such an argument now, on hindsight, the accused person through his legal practitioner cannot be held to be persuading this court to believe that there was nothing wrong with that. If they were saying yes, that is the case, we are sorry, it was an oversight, and then the lawyers won't perpetuate that argument, that would be understandable. But what is now before the court, that argument is now being perpetuated. That which happened, it was lawfully correct. An admission should have been made by the accused person through his lawyers that yes, that was wrong to have happened, to have taken place. And the use of the two names was wrong, even if they were both registered as trade names. But you find that the argument before this court is not about a concession being made that they were wrong, and that wrong approach was inadvertent. Why would the legal practitioners perpetuate a position at law which is wrong? That is what the state is saying. And that is not the end of the matter. If one goes through the Black Tech Private Limited CAPS account, you find that during the relevant time, they had a lawyer. They were paid 12 million, which was admitted by accused number one, that they were paid. There was a legal firm, law firm, Antonio and Chetero, who were paid 12 million RTGS, which was amounting to about 50,000 US dollars at the time, almost about that amount. But if that was an omission, that should have been corrected. That should have been corrected. The correct company, which was a law.
You said it was equivalent to USD what?
So about 50,000.
It should have been corrected by who?
They should have been corrected then, because the lawyer, when they were in this transaction. And Mr. Mindurwa also identified the lawyer in his evidence that the present lawyer was also involved in some of their negotiations. That if you go through, Mr. Mindurwa said so, identified that the present lawyer was also involved. Accused number one, lawyer of choice was also.
So you are saying that the use of Black Tech livestock in poultry,
yes,
was an intentional misrepresentation of fact?
Yes.
You deny the argument that it was out of lack of knowledge that the law had changed?
Yes, because this offense did not happen on a single day. When the fraudulent activity was perpetuated, even lawyers, they were involved in that during that whole process.
What would be achieved by the misrepresentation?
My Lord, the issue is that although the first accused may not have been represented in the beginning, but then along the way they got represented. And that issue of a company which was not a legal persona was never corrected.
Yes.
And it was expected that now that they were now being represented with someone who was being paid about 12 million RTGS should have been corrected. I didn't hear any evidence.
The point that I'm asking is that some people talk about misrepresentation takes many forms. There's intentional, there's negligent, there's what is normally called innocent. But I think the innocent part of it is captured in criminal law when they say the misrepresentation is criminal, is unlawful, or constitutes an offense if it is made with the intention that the other party acts on it to their prejudice.
Yes.
That is the misrepresentation which concerns us when in criminal law. So I want you to now fit that misrepresentation into that definition. Fair enough, it's common cause that black livestock and poultry was not registered.
Yes.
And that when the new law, the code was promulgated, there was now a requirement that trade name should be registered.
Yes.
So putting forward a company and naming it by its trade name,
Yes.
which is not registered, would obviously be a misrepresentation to the extent at least that it purports to be registered. You understand? But now I want you now to go further and explain to us how such misrepresentation would cause. That's why I said, what would it achieve in terms of the criminal context, that a misrepresentation is made with the intention that the victim acts upon it to their prejudice. I just want you to now explain how the misrepresentation was not innocent, as they say, because it was just, they said it's our trade name, we can use it.
Yes.
And this says unbeknown to the accused persons, there was the need, which would be a statutory offense.
Yes.
But I'm saying now let's fit that into the definition. Let us call it harmful misrepresentation,
Yes.
unlawful misrepresentation as contemplated in criminal law. Just I want you to now explain that.
My Lord, Honorable Assessors, I think with the codification of our law, it then brought in the principle of realization of real risk. Yes, as another concept of intention. The accused persons might have been, say it was an omission which was not deliberate, but because the fraudulent activity, it was continuous. What the state is saying, the first accused person took with him his lawyers to the Ministry of Agriculture in negotiating. They had an agreement between the government of Zimbabwe and the black livestock and poultry farming. At that point, if the mention of that name, which was not a legal persona, was not deliberate, definitely with the coming in of the lawyers, that would have been picked. What name was being used?
The use of that name was deliberate. That's what the first accused person said. He said it was deliberate. But what we want to know is criminal intent. Was it used with a criminal intent to deceive or to cause the ministry to act to its prejudice? That on its own, that's what I want you to focus
It was deliberate for the following reasons. Firstly, they were saying, the accused person in his evidence says that the company which entered into the agreement was Black Deck Private Limited. Then he also changed, he said that no, it was Black Deck in small letters, trading as Black Deck livestock and poultry farming. Then he changes on the second page of their bid document, the exhibit number 14. They said, no, it was Black Deck Private Limited, trading as Colenso Farm. Then they go on to change again, that it was Black Deck Private Limited, trading as Black Deck Livestock and Poultry Farming, and also trading as Colenso Farm. These are varieties of names which are being thrown in. So for one to therefore say which name was used in entering into the agreement, the accused person, the first accused person himself, is not committed to one particular name. Is not committed to one particular name. It's unfortunately there was no evidence from his lawyers to say which name was being used at law when the lawyers came in and were now negotiating with the ministry. And to also note that it was done with a criminal intent, it then brings in the accused person saying, no, the crux of his defense is that he was charged as an individual. He doesn't want to have anything to do with the companies. He doesn't want to be associated as a director. Now, when he used the Black Deck livestock and poultry farm, where he was not a director, it means he was quite aware that the use of these names is beneficial to one in their use in trying to get away with fraudulent activities. Good. Yes. My Lord, that is not the only issue which clearly shows the criminal intent. When the money was received, 1.6 billion, it was all poured into the black market. Despite the provisions of Bank Use and Promotions Act, that money was never accounted for. This was money from the fiscal, from consolidated revenue. Businesses are allowed to keep records, but an unregistered company is not allowed to keep records because it's not a legal persona. And that was the unregistered company, Black Deck Livestock and Poultry Farm. If one had gone to that company to look for records, it had no obligation to produce records because it is not a legal persona, it's unknown. That company could not have been penalized for not having records because it does not exist at law. So accused persons, accused number one in particular, he told this court that the transaction was done above board. Although an accused person in a criminal trial has no honors to prove his innocence, but however, if he makes certain averments that the money was used for its intended purpose, it naturally follows that he is to persuade the court by being candid in showing the court how the money was used. It should not be a word of mouth, my lord and honorable assessors, that one has to merely say, no, it was used above board, and you end there. Given the evidence which had been adduced by the court, that this money, when being flooded onto the black market, it was never seen again. There were no nostro accounts. If it was being kept, that was unlawful, because the law says one could not keep money in excess of $200 without being banked, in terms of Section 1011 of bank promotion use. Without doubt, the explanation by the first and accused persons, my lord, it was beyond reasonable doubt forced their version of events. In that they said it was the monies that they got was used above board. There is no evidence to that effect, despite the provision of the law that they are supposed to keep books of account. There is no indication on how the money was used, although he might say, no. The people, they must ask Black Deck Private Limited. But the state has already said Black Deck Private Limited was not the company which contracted. It was a Black Deck Livestock and Poultry Farm. Now, because it was that company which contracted with the non-company which was contracted with the government of Zimbabwe, it had no legal standing to appear before the law, before this honorable court, and be held to account. So the person behind it, who presented that company as if it was existent, is the one who did that in his personal capacity. And that was the first accused person. That was the first accused person. It is therefore the state's submission, my lord, that the version of the events is further beyond reasonable doubt forces that their defense was premised on the understanding that certain witnesses were going to be called, and such witnesses were available. There was Azwine Kabisira, who was there, who was the foundation of his defense. She's available, but she was not called.
How do you know?
No, that is what the accused person said. That he is not going to call Kabisira.
I'm just saying, how do you know she's available?
Because there was no evidence that was made that she is not available.
No.
Throughout the evidence, the accused person said, yes, I'm going to call her. No, I'm still contemplating whether I'm going to call her or not. Then he would say, no, I'm going to call her. But given their circumstances, definitely one would know her whereabouts. But that was not what was said. It was a deliberate move not to call her. And therefore, every evidence that was dependent upon corroboration cannot stand. All other witnesses who were listed in terms of Section 66, subsection 6 of the Criminal Procedure and Evidence Act were available, by the first accused person chose not to call them. The only witness who was not listed among the witnesses, the one who was said, who was in the summary of the case, is the expert that he was unknown when he eventually got to be known, Kundai Banya. He was then said he would be called, then the next thing he was dead, and there was no proof of his death. The state was not even asked to help for such information to secure his identity, to secure his presence, or to secure proof that he was dead. It was just a word of mouth that he was dead, and the person who was said to have brought the news that he was dead was accused once lawyer of choice.
Yes.
Yes.
Proceed, Councillor.
So, my Lord, without doubt, the explanation by the first accused person that he was not involved in the commission of the offense is without doubt false. He was the decision maker. He was the face of the company. No one knew Ajine Kabisiri. The accused person himself who said, I'm the operations manager. I'm the one who is out there, who sees everyone. Everyone else was working in the background. But he is the one who was the face of the company. Yes. So, really, in respect of the first accused person, my Lord, it is the state's humble submission that the state managed to prove its case beyond any reasonable doubt, and therefore it urges this honorable court to find him guilty as charged. Then in respect of the second accused person, my Lord, as already alluded to, evidence from Obed Jiri and Mindurwa was clear pertaining to the participation of the second accused person in the commission of the crime. He was given 200 million RTGS, which was in excess of 1.2 million. When he was called upon when he was asked how many goats of the 4,208 goats which were supplied to the ministry, he had supplied himself. He could not come up with an answer, despite being in custody for over a year. And he had been waiting for this trial for such a long time. One would have expected him to simply account it. A simple business transaction would not have been difficult to account. That he got that money and it was used in the following manner. But all he could say that yes, indeed, the 200 million RTGS over 1.2 million was received. It went into account. Within days or hours, it disappeared because money is supposed to be used. That he was quite clear about. That yes, when money is banked into one's account, it must be used. The question is, how was it used? He has no clue on how it was used. Did he buy vehicles? Did he buy provisions and so forth? But the evidence was very clear that Black Deck had a number of directors, whether registered or unregistered directors. It had managers. But he was the only one who was found where negotiations were being made in the company of the second accused persons. And the two, very close indeed. We did not hear the first accused person saying that he attended any meetings with other alleged agents, or he had attended any launches with any other agents. And all the ministry never referred to any agencies in their evidence. The impression that was given by other witnesses was that if you see Chimombe, you would have seen Black Deck. In the Mr. John Basera was lost of words in describing his participation, which he could summarize as having teaser, papa. He was running around everywhere. That is the extent at which he had seen him. So in terms of Section 196A of the Criminal Procedure and Evidence Act, it is clear that he knew that this was a scam which was going on, and the reason why he knew or must have known is that he was given also $200 million RTGS, which is over 1.2 million US dollars, which he never accounted for, which he can't even account for now. No one can handle that kind of money without accounting. Unless one is sure that the money is meant to be chewed, his money is meant to be used without being accountable. So that was his position. Otherwise, if he was an innocent businessman, his task was very easy, just to account, which he failed to do, which corroborated that his participation in the meetings with the Black Deck, he was part of the Black Deck officials, as narrated by the court. But otherwise, my lord, what the court is the court. I urge this court not to be swayed by the issue of one particular meeting. If one listens to the audio or the evidence recorded verbatim from Obed Jiri and Mr. Mindurwa, one would know that there was a lot which these two were doing in misleading. Even the issue when the gods were said to be 32,500, they were together. The audio that the state is referring to is the tapes being recorded by the registrar. So it is the state's submission that both of them, to show that they were the criminal intent, they had the guts, the nerve to go to the Ministry of Agriculture, said we have got 32,500 goats. Here are the numbers, here are the locations. The ministry unleashed its manpower in all the cells within the whole country. Only 3,000 goats, 3,700 goats, including 325 kids, were found.
How many?
3,700 goats, which included 325 kids, were found. When the two were called,
which included how many kids?
325. When the two were called, when the Black Deck was called, accused person came, he came with accused number 2. And they started discussing this issue of goats. And they said, yes, no, the goats, they are not there where we had said they are there. They are scattered with farmers. But no, we can't go there. They refused to go and verify the goats. Up to this day, the 13th of October 2025, those 32,500 goats were never found. if he was just if they were just simple participants representing a company, why would they talk about non-existent courts? That is what broke the camel's back. These people, these two, in trying to mislead the ministry, they had an intent. But otherwise, the state has proved its case beyond any reasonable doubt, and therefore it urges the two to be found guilty as charged. That is what that the state wishes to say, madam.
Thank you. How many minutes did you utilize?
What did you say? 5 minutes? I said 5 minutes.
Mr. Jetero?
Oh, yes, ma'am. Thank you very much. I noted my brother took 45 minutes. Use only 5 minutes.
So you will have 45 minutes.
I'll be
In all fairness.
indebted, my lord.
But you don't have to utilize them all.
I'll try to be brief. My lord, I want us to start off from a point where we get some other things out of the way. I want to start with this issue relating to the allegation by the state that the accused person, the first accused person, used a non-existent company. My lord, it should be made clear that the evidence led so far until the close of the state case, all witnesses were clear that whether one was referring to Blackdeck livestock and poultry farming, or Blackdeck Blackdeck trading as Colenso farm, they were all referring to one and the same entity.
Repeat.
None. Okay, I'm saying there
Witnesses were clear.
witnesses were clear that whether one was referring to Blackdeck livestock and poultry farming or Blackdeck trading as Colenso farm, they were all referring to one entity, a non-entity, a registered entity. That entity is known as Blackdeck Private Limited. It is one argument to say that the accused persons were using unregistered trading names than to say they were using a non-existent company. Those are two different.
Try and restrict yourself to the first accused.
Okay, my lord. The first accused in this sense, my lord,
In
whenever.
the sense that you are submitting on his behalf.
Yes.
Don't speak for them.
Yes, my lord. Maybe when I have a slip of the tongue, I'm referring
We
to the
know that
first.
when you say them, you mean. the
I
first
mean
accused.
him. Yes, I mean the first accused person. So, it is one argument to say when a person is referring to an unregistered trade name, to say a person is using an unregistered trade name is different from saying the company is non-existent at all. Because for the state to allege that the company is non-existent, it's a false argument and it's not based on any evidence laid so far. The person who drafted the agreement testified, the legal person, Chenai Garisinet. She indicated that the trade name, the name that was used, was referring to a registered entity, and that entity is Blackdeck Private Limited. So it must be out of the way that the allegation that accused person used a non-existent company is totally false, and it has no basis based on the evidence laid. Now, I'll then come to the aspect of the use of unregistered trade names. That aspect, my lord, my learned colleague has related to a section of the Companies and Other Business Act, which I would wish to relate to. The first starting point that must be borne in mind is that the accused person is not being tried in this particular case for breaching that section. That is not the offense that he is facing. But nonetheless, even if it were to be assumed that he is being tried of breaching section 29 of the Companies and Other Businesses Act, it must be borne in mind, my lord, that that act came into effect after the company had already used the trade name. The interpretation that I have with respect, my lord, is that the section does not apply in retrospect. There's no retrospectivity given to the section. The section states that subject to this section, a registered business entity may assume a name other than its registered name for use in conducting business in Zimbabwe. So by that, it is referring to as at the date of its inception, where there is a company that wishes to use a trade name after this act has come into effect. When it assumes that trade name, when it obtains, when it acquires the trade name, it is then therefore required in terms of subsection 2.
So the state was correct in saying you persist that there was nothing wrong with the use of this name. Is that your position?
No, my lord, I am saying my interpretation of this particular act as we are going is that the act does not require companies that he had already assumed prior to its inception.
In other words, there was nothing wrong with the use of this name because it had been assumed prior to the promulgation of the act.
Yes, that is my interpretation.
We should be the, no, we want an interpretation which should be the interpretation you want us to accept.
Yes, my lord.
Because if you are saying that in order to persuade us to make that finding, then we need to know, is that what you are persuading us to find? That, look, you really can't be complaining about the use of this, the state cannot be complaining about the use of this trade name. Black Deck Private Limited was entitled to use this name, notwithstanding the promulgation of COP.
Indeed, my lord. That is the interpretation that I am submitting that this court should find of the
So in other words,
section.
the law did not apply to companies already registered which were already using trade names.
Yes, that is my interpretation, my lord. And I say so because it is clear it does not say company that assumed trade name as opposed to register their assumed trade name. It says where a company wishes to assume a trade name. And you then go and look at the act. And we all know that constitutionally, an act is presumed not to have retrospectivity unless if it is clear in its meaning that it has retrospective meaning to it.
Just a second. I would suppose that an intervention by the law, particularly of this nature, which requires trade names to be registered, would be targeting a mischief.
Yes, indeed. Indeed, my lord.
So, how would the mischief be effectively dealt with if the law did not apply to companies that were already registered and which had already assumed trade names. If they are exempt, well, how do you draw the line? How do you do that? In other words, I was almost tempted to mention names. But only assuming there is a company, we know of many,
Yes.
which we don't need to mention,
Yes, my lord.
that are registered, but they used trade names.
Yes, my lord.
Yes. And assuming that there are other companies which are not using trade names, and then they start to use those trade names, can they not simply say, no, you know we have already been in existence. We have already been using this. How do you deal with that mischief?
Yes, my lord. I do hear you, my lord. And the submission that I make is the same interpretation that goes to crimes that are created by statute. That if someone, say for example, theft was not an offense, and then there's a statute that comes and says no one can steal. So if someone had stolen 2 days before, that person would not be covered by that act. And in the same manner, if a company had been using a trade name,
obviously, if Black Deck Private Limited have been charged with a crime,
yes,
which arises from contravening that prohibition,
yes,
which we know exists,
yes,
in court,
yes,
they could not be charged for contravening it prior to the promulgation,
yes,
but they could be charged for it subsequent. But what you are saying is that they could easily escape that
yes,
offense by
yes,
saying we were already using this trade name, so
yes,
we are not covered by this prohibition.
yes, yes, my lord. And to clarify this, the act itself, in paragraph number 2, it says before the company assumes the name, it must register it. So it really speaks of the present day going forward.
So all companies registered prior to the COB,
yes,
could simply spring up trade names and escape liability on the basis that they'll say we were there before, we're already using this. You may not know, but we're already using it.
It becomes a matter of evidence, my lord, in my respectful view. If a company springs up a name and the state manages to prove that this name was sprung up after this act, obviously that would be a contravention of that
So it
section.
becomes a matter of evidence.
Yes, my lord.
Who would be adducing that evidence?
Is the state, if it is alleging, because the state bears the onus of proving that this person has committed a contravention of this section.
Oh, so it was up to the state to prove
Yes.
that this name was not already in use.
Yes.
How?
It should have employed maybe by adducing evidence to say that this name was adduced then, or even making that allegation.
No, how does the state prove that the name was not being used?
No, I'm saying, my lord, whenever the state makes an allegation, it must prove it. If the state alleges that someone contravened this particular section, it bears the honors, my lord.
If the state
But
alleges that you did not register this name,
yes,
trade name, and the defense is that we were using it before,
yes.
how do you lay a basis for that defense?
Oh, yes, okay. I was talking of a scenario where the state just makes the allegation. Mm-hmm. But
I'm just saying, in this case, we know that your client, sorry, I don't know whether Black Deck is your client. It was.
It was when I was paid the 50,000 that my friend is very jealous of.
Assuming Black Deck Private Limited was
yes,
charged with
yes,
that,
yes,
which we know it wasn't.
Yes, my lord.
And then it says, as part of his defense, we are not covered by this prohibition,
yes,
because we were already using this name prior.
Yes.
How does it lay a basis for that defense?
Yes. Yes.
How does it do so?
Yes. Oh, yeah. My lord, I do hear you, my lord, because it is a scenario where, for example, like an alibi, where someone says...
You actually read my lips?
You were crossing a red robot, and the person says, I was not even at Samora, I was somewhere else. Yes. The onus now then shifts. So in other words, the onus would shift if someone is raising as a defense to the charge to say, oh no, we were already using this, but all the same it is a matter of then evidence, my lord.
Yes. How is it different from this scenario? Assuming you are even correct that
Yes.
the act did not apply to companies already which had already assumed. Let us just accept that for argument's sake.
Yes, my lord.
How is it different now? Is it not a defense that their state is simply saying the name does not appear in our register? And your client says, no, we were using it before.
Yes. Yes.
Doesn't the onus shift? Well, at least to the extent of establishing a basis for that defense.
Yes, my lord. For starters, my lord, I wish to put it that, like what I had indicated, that the state has not charged, not even Black Deck Private Limited, for contravention of this section. This has actually sprung out during the course of the proceedings to say, oh no, these were not registered in terms of this section. So in a response to that, the first accused then mentions that, well, I know that the company Black Deck Private Limited was using these names prior to this and from its inception. And when I acquired this farm, we were then, and I acquired this farm prior to this act, and this is why we were using. He then explains, and this is what is required of him to say as an explanation. He does not bear any proof because he is not being charged with contravening that particular section, my lord. Thank you, my lord. So, and the offense, the charge that he faces, my lord, from the state's perspective, from the charge sheet, from the state outline, which has not been amended up to the closure of this case, is that he used an unregistered entity. And I'm saying that should be put off because there's no question. Everyone knows the CRR 14 that were referred to, the documents that were submitted in the bid, they all refer to a registered entity. So that part of the allegation of the state dismally falls away. If the state now wants to shift the basis of its misrepresentation to be on the basis that they were using unregistered trade names, it's totally different, and they must say so. They must not hide behind saying it's an unexistent company and then say, no, but in any case, the trade names were not registered. In which case, the first accused person can then gladly really relate to that issue. The state should not do carpet bombing, as it were. They must mention the basis of the charge. In the charge, it must be clear that if they are saying you misrepresented that this trade name was a registered trade name when it was not, it's totally different from what obtains in this particular case. So on that basis, my lord, it should be taken that the company that we are dealing with is registered. I'll then move, my lord, to another matter that I wished to just have out of the way. It's the state must be clear because the offense of fraud has essential elements. I would have expected my learned colleague to have said, these are the essential elements. Let us deal with the element of misrepresentation on the part of the first accused person. And let us clearly outline how he misrepresented. So the act of misrepresentation is one where someone represents false state of affairs to be what it is not, when he knows that it is not. It's very clear from the charge sheet, my lord, that the misrepresentation is alleged to have been done in writing, in the form of a document, which is a bidding document. That must really be clearly laid out. The state itself, even in its submissions, in paragraph number 46, of its closing submissions makes it clear that whichever evidence that came after that was only coming to show prejudice of what the state was prejudiced. So we are then supposed to focus ourselves when we are relating to the actus reus, to the period of when the bid was submitted. And that period ends with the exhibit that relates to the award of the tender, which was on the 3rd of November 2021. So this is when the offense was really committed. So when we then get there, we must then get the actus reus of what the first accused person is alleged to have been done. That is very clear and that is very simple. And the state must simply say, this is what he did. I do hear my learned colleague to be saying, this case is one that is based on circumstantial evidence. And if the state states that, from that inception, we must know that then there is no direct evidence of what the first accused person is alleged to have done in contravening of this.
You mean in the sense that there's no direct evidence which shows that he submitted the bid?
Yes, for example, or that he compiled, or
that he compiled the bid.
He compiled the bid, and he made a representation. There's no direct evidence that the first accused person made any representations to the minister. So what then the state must do, in my respectful view, is to then say, from all these other evidence that we've proven, and this is the rule of circumstantial evidence, all this evidence shows that it is the first accused person who misrepresented 1, 2, 3, 4, 5. This is what I should be hearing the state's allegation to be saying. But they are not saying that, my lord. They are not saying that.
At West, who made the misrepresentation?
Yes, my lord. At the West, my lord, assuming that what is being said to be, forged and blah, 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 is proven or is taken to be what it is being alleged to be. Mm-hmm. It would be the person who compiled. It would be the person who submitted that, because that person would have... In this case, my lord, I would say it will be...
Which is that person?
Yes, I would say, for starters, my lord, it will be Black Deck Private Limited. Or if it is then shown, like in this case, where someone says there was Teach Them who did this under the supervision of Ajne.
Assuming it was Teach Them.
Yes.
Who made this misrepresentation?
Yes, my lord.
Assuming it was the person to whom the job was, if we accept that argument, outsourced?
Yes, my lord.
This is Bwanya.
Yes, Kunde Bwanya, my lord.
You mean it would not be Black Private Limited?
Yes, my lord. I'm saying, for starters, we start off from who compiled, who submitted, and we then say, for argument's sake, it is Ajne and Teach Them acting for Black Deck Private Limited. In my view, then those must then be answerable. Those are the ones that must be in the
in other words,
in the dock.
Yeah, I wanted to know whether those people, Sharon Bwanya, if we accept that she's the one who procured this document, and who is the other one who signed? Chidembo.
Yes, Teach Dembo, my lord.
Teach Dembo.
Yes,
those people would be separate from Black Deck Private Limited.
Yes, my lord. If it were up to me, if I were the state, my lord, I would have charged. Teach Them. I would have charged Ajne Kabisira, and I would have charged, for example, and I would have charged Black Deck Private Limited. But then, when they are then in the dock as their defense, they'll say, "Oh, when we compiled these bidding documents and we put these two documents that are offending, we genuinely believed that these documents were genuine because we got them from Kundai Bwanya. The moment they prove that, then it negatives the mens rea of that offense in their respect.
Where I really want you to assist me is whether Chimombe,
Yes, teach them.
Chimombe, who is the other one?
Ajne Kabisira, yes.
Ajne Kabisira is the one who is said to have delivered the...
Yes.
And then there is also Sharon Bwanya.
Kundai Bwanya, my lord.
Kundai Bwanya.
Kundai Bwanya, yes, my lord.
Are these people different from Black Tech Private Limited?
Yes.
They're separate.
Yes. Yes, my lord. They are.
They're separate liability which does not affect Black Tech Private Limited.
No. In some instances it does, my lord. In some instances it does, my lord. For example, my lord, these are different personnel, my lord, because for starters, that bidding document belongs to Black Tech Private Limited as a separate person.
It's actually the reason why I keep asking you this.
Oh, yes.
They were doing this on behalf of...
Black Tech Private Limited.
So how would Black Tech Private Limited not be answerable?
No, it should, my lord. In the very first instance, it should. This is why, my lord, I'd said that... yes, it should, my lord. Black Tech Private Limited must explain its bidding document. This is why I'd said if I was the state, I was going to charge Black Tech Private Limited as accused number 1. And then maybe Ajne as an accused number 2. And teach them as accused number 3. And Kundai Bwanya, if you are still existent, as accused number 4. And this is what I think,
and
because...
Black Tech Private Limited is separate from the first accused person.
Yes, it is.
When we say Black Tech Private Limited is answerable, who are we talking about?
Oh, yes.
We are talking about who?
For starters, my lord, Black Tech, when we say Black Tech Private Limited is liable, if we assume that, we are talking of it as a company.
Yes,
it can be fined. It can, if the court then finds that, say for example,
no, I'm just asking, assuming the state had decided to engage
yes.
Black Tech Private Limited.
Yes.
Who does the state engage?
Or for starters, the Black Tech must make a resolution to say, in these proceedings, we are appointing either the first accused person as one
without
of the directors or someone else.
Without a resolution?
Oh, well, without a resolution, the state is even at large for itself. If it feels that, say for example, let's say Ajne, for argument's sake, I'm not saying she is guilty of anything, or even the first accused person, the state is allowed, my lord, to have said, look, we believe that this offense was committed by Black Tech Private Limited, and we believe that you were also personally liable, and the Act allows that for personal liability. My learned colleague mistook the argument that we're putting about corporate personality to say we are saying there must be upliftment of corporate value. No, the Act is clear. It says a director can also be criminally liable for the acts of the company. But where you do so, my lord, this is the necessary submission, which I think my learned colleague is missing. You must then charge Black Tech Private Limited as a first accused person, and then accused, if the state felt that it is Moses Mpofu because he's the mastermind.
No, we'll get to that, obviously.
Yes.
I know that you made submissions in that regard. I just want to understand, for practical purposes,
yes.
If Black Tech Private Limited does something that requires an explanation,
yes.
maybe by the investigating officer,
yes.
or we are just,
yes.
isn't it?
Yes, ma'am.
Black Tech is a fiction. Private Limited is a fiction. We all know that. You can't touch it. You can speak to it, but how do you speak to it? That's what I'm asking.
Through people, yes, my lord.
Yeah, who do you speak? You want to speak to Black Tech?
Yes.
Who do you speak to?
Yes.
Because we know that it is a fiction, it doesn't exist.
Yes.
It's a fiction which is seen by people who are in the legal realm.
Yes, yes. It's an incorporeal, yeah.
Yeah, it's incorporeal, those big words.
Yes.
But we are just saying, the law said, let there be a company which shall be a person.
Yes.
That's our own creation there.
Yes, that's our
But
creation.
unfortunately, we could not give it limbs. We could not give it
Life.
life.
Yeah.
Now you want to speak to this fictional person. Who do you speak to?
Definitely.
Before even it starts giving you passing resolutions to appoint representative, who do you approach?
You approach a person, one of the directors, any of the directors, and say, look, I want to speak to, I want to inquire. Let's say if it was the IO. You must go and say, there's this issue about Black Deck Private Limited, which submitted this bid.
Do you approach one?
Or you may approach them all. It's really up to, as long as...
Who does the thinking for the company?
It depends with how the company...
I know at law. I want to know at law, who does the thinking?
It's the board of directors.
The board of directors.
It acts through.
So in other
board
words,
directors.
you are, if you do it correctly,
Yes.
you are supposed to gather them and say, you are the board. I have come to talk to Black Deck. I want to talk to you.
Yes.
Isn't it? So
Yes.
it's the board.
Yes. Yes, my lord. The board can then say, look, this is the director who's responsible or who's answerable, or this is the person we want you to speak to. Then you then speak to that person. But if you then just go to Moses Mpofu and get him and you say you are our accused person, you must then prove the actors of Moses Mpofu as a person for him to be convicted. You cannot then just hope that if you prove an offense created by a company in which he sits as a director, he must also then be obviously be liable. It does not work that way. You must mention the offense was created by a company as accused number one, and the company is then represented by Moses Mpofu. Then you, in
other words, you are saying a company does things ordinarily. The brain, the soul, the everything is the board.
Yes.
And so if you cannot, you must deal with all of them. One must deal with all of them. You cannot.
It's the first instance, yes, my lord. And,
okay.
and the company must then say, the company ordinarily would make a resolution. I think there's a section in the criminal procedure.
So a member of the board
Yes.
is not personally accountable for the decisions made by the board.
Criminally liable, unless if he has personally acted in a criminal manner. That is the submission that I make.
Okay, but anywhere else is accountable. You are saying if somebody is part of a meeting of board of directors and they
Jointly.
agree on something,
Yes.
and then they say this is our position as Black Deck Private Limited.
Yes.
Any member of the board is not personally accountable. That's what you are saying.
Criminally, yes, my lord.
Or criminally.
Yes, my lord.
Oh, okay. Okay. You were going to refer to, you were now touching on the law regarding this. Now you can go into it. You were saying that the company ought to have been charged
Yes.
for the accused person to be
linked to the offense.
Okay.
There must be a nexus. There must be a link between
What is your
the
authority
commission of the offense and the person.
What is your authority
Yes.
for that?
For that, my lord, the cases that I was referring to in civil cases, where my learned colleague was saying, I am then saying the corporate veil must be uplifted. But I'm saying those cases go on to explain the legal relationship of a company and I then go on to say, if this is the position in civil proceedings, when we are now dealing with someone's liberty, criminal, the threshold is usually higher. That is that is very trite.
No, so you want us to make that law that when the threshold is higher, is there no legal framework that applies to criminal cases?
My lord,
You are saying you are borrowing concepts
yes,
from company law and broadly civil, isn't it?
yes.
Yeah. Is there no legal framework in the criminal law which so that you are saying this is what the law says in the civil?
Yes.
So when it applies, we must then say the threshold. is there no specific legal framework that applies to personal liability in criminal cases?
Indeed, my lord, I believe the Criminal Procedure and Evidence Act has some sections where it
you referred to section 385, did you? In your closing submission?
I did, my lord.
Yes, I saw that somewhere.
Yes, I did, my lord. I think it's section 385.
385.
That's beautiful.
It's of the Criminal Procedure and Evidence Act.
Yes.
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 Yeah.
That is
unfortunately, you did not quote it, so
the,
you can now relate to it.
my apologies, my lord.
It doesn't matter. We would find it anyway.
Yeah.
So it's not always necessary to do so. You only need to draw attention to a provision. So it said it's three.
It's section 385, my lord. 385 in particular, subsection 2.
385. Let me get there first. Taking time.
The problem is with me, my lord. I ought to have quoted it verbatim.
385. Yes, I'm there now.
Yes, subsection 2.
You can take us through.
Subsection 3.
What? Why don't you take us through section 385? Subsection?
Subsection 3, my lord. Section 1 deals with the definition of what a director is, and then subsection 2 was then amended or repealed. Then we are left with subsection 3, which then says, in any criminal proceedings against a corporate body,
Yes.
a director or employee of that corporate body shall be cited as a representative of that corporate body, as the offender. And thereupon, the person so cited may, as such representative, be dealt with as if you were the person accused of having committed the offense in question. So the submission that I make from that, my lord, is that the state is not precluded. In fact, it is empowered by this section to charge any director as a representative, as it were. In fact, like what I had been indicating, that what the state ought to have done would have been to say the first accused person is Black Deck Private Limited. The second accused person is Mpofu as a representative of Black Deck Private Limited. And once they would have done that, that would then attract criminal liability to Moses Mpofu. This is what this section...
I think you are alluding to procedure,
yes,
as opposed to the substantive law of criminal liability.
Yes.
This is just telling the courts that where a company is being prosecuted, the director should be cited.
Yes,
and
as a
when he
representative.
appears in court, he can be named the accused. He is required to do everything that the accused would do, as if he was the accused person.
Yes.
That's all that section is telling us. In other words, when you say what is it?
Black
Assuming
Deck.
Black Deck Private Limited in charge.
Yes.
When we say Black Deck Private Limited,
Yes.
he's the one who walks into the dock.
Yes.
As if he were the accused person.
Yes.
That is what section 3 is telling us.
In part, yes.
It's just a procedure. But where do we find the law, the substantive law on criminal liability? Criminal liability is not found in procedure. It's found in the substantive law,
Yes.
which creates
Yes.
criminal
Yes.
liability.
Yes, my
Where is
lord.
that law?
Yes, my lord. It's there, my lord, in the sense that criminal liability can only attract where the state proves actus reus and mens rea.
Yes, where do we find that law?
Well, it's common law, my lord.
No,
But
no, our criminal law is no longer
and now, my lord, in the code, for a crime of fraud, for example, it's codified in the code. And it says for someone to be convicted of fraud, that person must have done 1, 2, 3. That person must have done misrepresentation as...
I thought somewhere in your heads of argument you alluded to criminal conduct or criminal liability of person. Where do we find the law which tells us circumstances under which a person is criminally liable? It's certainly not the Criminal Procedure and Evidence Act, because that is just procedure. Or when you are dealing with somebody who, according to this, is already criminally liable to be charged. But where do we find criminal liability? Where do we look for it?
If you could just bear with me. If you could just bear with me. I'm indebted to my brothers, my lord. They've directed me to section 277 of the code. And then section, it deals with criminal liability of corporations and associations and their members and employees and agents.
Just a second, I want to get there as well.
Thank you.
Section 277. You will recall that this is a section that we alluded to in our judgment at the close of the state case.
Indeed. Indeed, my lord.
Let's see. Now, find the relevant portion.
Yes, my lord. It should be subsection 2.
You can read the whole of it.
It should be subsection 3. It says, where there has been any conduct which constitutes a crime for which a corporate body is or was liable to prosecution, that conduct shall be deemed to have been the conduct of every person who at the time was a director or employee of the corporate body. And if the conduct was accompanied by an intention on the person who at the time was a director or employee of the corporate body, provided that if it is proved that a director or employee of the corporate body took no part in the conduct, this subsection shall not apply to him.
Yes. Can you interpret that?
Yes. It says that the directors, the board of directors of the corporate, where it is alleged that the corporate is liable, you can find the members, the directors of that company legally liable for the sins of the company. But you have to prove conduct.
Say that again.
The submission I'm making, my lord, is that this section provides liability for the directors on behalf of the corporate that they represent, if their conduct is in line with it.
What it says here, where there has been conduct which constitutes a crime for
Yes.
which a corporate body was liable to
Yes, yes.
then the director
Are liable, yes.
Is or are liable.
They are liable. Them as a whole.
So, if Black Tech Private Limited was liable to be prosecuted,
Yes,
its directors were also liable.
yes,
That is what it's telling us, isn't it?
yes.
Where does it say that the Black Tech Private Limited should have been prosecuted?
So, if you could just be with me. Yes, my lord, I'm being minded, my lord, by my instructing that from before subsection 3, it starts off to say any conduct.
Maybe so that you don't get confused with the agreement with all concerned. Maybe you could rest your submissions and then Mr. Koto can come in. If we were
Well, he was going to come in, my lord. But
when he whispers to you, he might disturb your trend of thought. I don't know what the bar thinks.
I do
was
agree, my
thinking
lord.
that maybe so that you don't get disturbed. If Mr. Koto has something to add, you can always ask for permission to add his voice. We have done that before.
Yes.
What do you think?
Indeed, my lord, I must mention that.
I think we agree with that.
Rather than him whispering, you don't have time to process what he will have told you. Just concentrate. Mr. I know you are burning. You are.
Thank you for
we will
that.
hear you. Yeah.
Thank you for that
We
indulgence.
should actually give you. So you can proceed. Just focus on my questions.
Yes, my
I
lord.
was simply saying, does your reading of that subsection imply that the corporate body itself must be charged for there to be personal liability, on the director?
Indeed, my lord. It must. The corporate body, in my view, must be charged, or at the very least, the state must indicate that this person is being charged for the offense of this corporate body.
Thank you.
And the state is not doing that. And then it goes on in its provision to say, provided that if it is proved that a director or employee of this corporate body took no part in the conduct, this subsection shall not apply to him. So it then takes away even liability of a director who did not participate in the conduct itself.
I thought the traditional position before codification
Yes.
was that it is the natural persons who do things,
Yes.
who do acts, commit omissions. Does that make sense?
Yes, I think that
and
is where
then
it comes
the
from.
corporate becomes vicariously liable.
Yes.
In other words, these things are done by people.
Yes.
These
Yes.
people who have hands, who have minds. who have
Yes,
this.
yes.
Then the company, because these are the people who do the thinking, it becomes vicariously liable.
Indeed, my lord.
Yes.
I agree.
So liability starts with who?
It starts with the person, my lord, with the person who does something on behalf of a company, and then when that person then comes and says, no, but this is the act of the company, then the company goes back to the person. I think this is the mischief, my lord, that the act was trying to deal with, which is really what the common law position was.
Is subsection not telling us that it's absurd to talk of a company without attaching liability to the drivers, the people who are doing the acts?
Indeed.
Is that not what it's telling us?
It is, my
But
lord.
as soon as there's something wrong that has been done by a company, ipso facto,
Yes.
the people behind it are liable.
Yes. Yes, indeed, my lord.
So why do you say that a company should be charged first? Because it is only attracting
Or
liability because of what a natural person has done.
Maybe when I say first, my lord, but I mean it should be the link
No, I see.
to the offense. It should be the nexus. You must then say Black Deck Private Limited did this. So once you then prove that indeed Black Deck Private Limited did something, you don't need to then go a step further and prove that this director is also criminal liable. This is what the act is really giving truth. To say where the court finds a company did something wrong, it can then grip on a person, on the directors, as it were. Yes. So and then that becomes the nexus. But the moment you then just take John from Norway and you just charge him personal, without mentioning at the very least that this offense, we are saying it's company A, B, C, D which did this.
So when a company is charged with an offense,
Yes, ma'am.
and the director is charged with the same offense,
Yeah.
are they one thing or they are co-accused persons?
Well, there will be co-accused persons, my lord. For starters, the state must indicate in what capacity a person is being charged. Because if a person is being charged in a representative capacity, that must come out of the charge, yes.
And if it's being charged in his personal capacity?
Once the...
Is he being charged as Black Tech Private Limited or as a co-accused? I just gave you that scenario.
Oh, okay.
There are cases where the company itself is charged.
Yes, my lord.
And he may still be the... In
Yes.
terms of the law, in terms
Yes.
of our criminal procedure,
Yes.
he is the person to be arraigned.
Yes.
Because he's a director.
Yes.
And he may be charged in his personal capacity.
Yes.
As well in the same
Same offense, yes.
So will the state be dealing with one person or two persons as co-accused persons?
Okay.
In that scenario?
Yes. Yes, my lord. Actually, I wanted to give a third on top of the two that you have given me. That the state can charge, say for example in this particular case, Black Tech Private Limited is accused number 1 and Mpofu is accused number 2. Either Moses in his official capacity as Black Tech Private Limited.
No, it's never that way.
No,
It's Black Tech Private Limited, but the procedure for the practical purposes says
yes.
the state drags the director
As a
court in his representative, which is why the reason why he can't be jailed.
Yes.
He can because he's appearing in it. And I'm saying now he's charged in his personal capacity. Are these people appearing as one entity or are they appearing as co-accused persons?
Oh, well, my lord, maybe if I was going to finish on that, my lord.
Yes.
I was saying, in that case, maybe they can then charge Mpofu in a representative capacity of
Yes.
the first accused person. That is scenario number 1. They can also charge him in his personal capacity, not as a representative, which is different. And then the third scenario is they can charge him in both capacities, as representative and personal. The reason why, my lord, I am really mentioning a representative capacity, you would note that from the section that I read in the Criminal Procedure and Evidence Act, it says you must then be charged as such in a representative capacity. It's because the criminal liability differs. Because once you say somebody is answerable personally, you must prove personal action. Once you say representative capacity, we are now talking of vicarious liability. You don't need to then have done...
I was hoping that we were not going to dwell on this. When does it ever happen that a director is charged in a representative capacity?
Yes, my lord.
I thought it is the company which is charged. It is the company which appears on the charge sheet as the accused.
Yes.
And then the law is telling us, of criminal procedure is telling us, because the company does not speak, the person you must then, who must represent that company, who must come to court,
Yes.
is the director.
Indeed.
In other words, his name will not even appear anywhere as the
Yes.
accused.
Yes.
The person who will appear as the accused is the company.
Indeed,
So,
my lord.
so there can never be a situation where anybody is charged in a representative. That would be wrong. What is charged is the company, and because we need somebody to talk to, we say, come and speak on behalf of your company. You are not the accused, but you are speaking on behalf of the company. So that's scenario number 1.
You have put it eloquently, my lord.
Thank you
That
very
is
much.
what I was trying to
Yes.
to relate to.
henceforth say it the way I'm saying it.
Yes.
Then the accused person, as in this case, Mr. Mpofu, was charged in his capacity. In other words, Black Tech is not here.
Yes.
It will not be fined, even assuming it did anything wrong.
Yes.
Yes. So that's in his personal capacity.
Yes.
Yes. So I'm saying where they are charged, both of them, are they one person? Do we conflate them, or we are dealing with two accused persons? Black Tech, which may be fined or may have his assets taken. Is that that's what the criminal
Yes.
procedure says?
Yes.
Isn't it?
Yes.
And the accused who may go to prison,
Yes.
isn't it?
Yes,
So
my
those are two co-accused persons, isn't it?
Yes, my lord.
Okay.
Yes, my lord. Yes, my lord. So, in this particular case now, what the state is starting off from saying is that there is no corporate person to talk about. The corporate person is non-existent. and we are dealing with you, Moses Mpofu, in your personal capacity. So once the state then does that, it must prove conduct on the part of Moses Mpofu. It must not then want to sneak in through out of loss of a
No,
good
it's
will.
fine. It's fine. You can proceed.
It must not want to sneak in through the doctrine of vicarious liability to Moses Mpofu through the back door.
Who is bringing in Black Dick Private Limited?
Oh well, is the Moses Mpofu has been charged now. There's this. He then says, look, these are the conduct and actions of a company, of a corporate person. That's what he's saying through the...
He is the one who is doing that.
Yes, in his defense.
And I'm asking you, assuming he succeeds to
Yes.
bring in the company, and
Yes.
say, well, Black Dick should have been charged.
Yes,
Does that exonerate him?
it does.
I see.
Unless if the state, it then... Because the state has had the charge sheet. The state has had the defense outline. If I were, the submission that I make is what the state then ought to have done, at the very least would have been to amend their charge and say Black Dick Private Limited is accused number one. Or withdraw the charge against Moses Mpofu and then charge Black Dick Private Limited and arrest Moses Mpofu. You would then, in that scenario, my lord, you would have been properly placed now to deal with Black Dick Private Limited's
Also,
issues
you are saying
within...
the liability of the director is parasitical, in the
Yes.
sense that the state must necessarily prove
Yes,
for his criminal conduct,
yes,
the state must prove his case against the company.
yes.
If it fails to do that, then there's no personal liability attaching to the director.
Yes, well,
That's your understanding of this.
yes, my lord. The state must make a choice when it wants to prosecute a person and when it relates to offenses of a company. It must make a choice to say, to state in its papers, to say the offender is Black Dick Private Limited, but we want Moses Mpofu to explain. So that is the position that I really wanted to get off from the onset. Thank you very much, my lord.
Have you finished reading section 277?
Yes, I finished with the provision. Yes, there were other sections, subsection 4, 5, which I think are not on my feet, which I think are not applicable. But if they are,
What
I
does
think
it
my
mean
learned
when
colleagues
the law
can.
says the conduct of the corporate which was liable for prosecution is deemed to be the conduct of the director?
Yes, yes,
What does that mean?
yes, my lord. In my respectful view, my lord, what the section is doing there, it's giving the burden to state to say once state proves liability of the corporate, it stops there. It's a deeming provision to then say that conduct is then transferable to the person. In a way, it is coming in to say it cannot be a defense if this offense was in respect of Black Dick Private Limited. Moses Mpofu would not, in my respectful view, in terms of this section, be not entitled to say in his defense, oh, these are the acts of Black Dick Private Limited. If the state had charged him if the state had charged Black Dick Private Limited, and Moses Mpofu would have been charged as a representative.
No. We know that we are not dealing with Black Dick.
Yes.
I'm just saying, does the state have the prerogative to charge and not to?
It's the dominance it does, yes.
So if there are two accused persons or suspects and the state decides to charge one,
Yes.
does that mean that it cannot charge the other?
No, it does not mean that, my lord. It does not mean that, my lord. But where the state wants a person to be responsible for the acts of a company, the state must mention it.
Okay. Thank you.
And in this particular case, it is not.
Now you can go back to section 385.
Oh,
There's a section that we want you to help us interpreting there.
Okay, my lord. Yes, my lord.
It was 385, was it?
Yes.
Subsection 4.
Did my lord.
Can you just read it?
Oh, indeed, my lord. I was trying to read it. In any criminal proceeding against a corporate body, any record which was made or kept by a director, employee, or agent of the corporate body within the scope of his activities as such director, employee, or agent, or any document which was at any time in the custody or under the control of any such director, employee, or agent within the scope of his activities as such director, employee, or agent shall be admissible in evidence against the accused.
Yes. What does that mean?
It means in criminal proceedings against a corporate body. It applies to criminal proceedings against a corporate body. So in my respectful view, it is not applicable in this particular matter because these are not criminal proceedings against a corporate body. And this is what I keep on relating to say the state must have made its stance to say, are these criminal proceedings against a corporate body? Once they make criminal proceedings against an individual, it's a different ballgame. They cannot even rely on this particular subsection.
You have not told me what it means. You said it doesn't apply to the accused.
Yes, into these proceedings, because it limits itself in criminal proceedings against a corporate body.
Or against the accused, which is the corporate body.
Yes.
Subsection 7.
In any proceedings against a director or employee of a corporate body in respect of an offense, any evidence which would be or was admissible against that corporate body in a prosecution for that offense shall be admissible against the accused person.
What does that mean?
In my respectful view, my lord, it means that in proceedings against a director or employee of a corporate body, any evidence that would have been admissible in respect of the corporate is also admissible in respect of that person.
Yes, if he is the accused person, isn't it?
Yes, if he's the accused person, I would go on to say the reason why they mention a director is because he's coming in from that capacity of being a director or employee of that corporate body.
What does that mean? I'm failing to understand. Okay, a person who is personally liable is not coming in any capacity other than in his personal capacity.
My lord, the submission that I'm making is that, like we have indicated, that the corporate body does not have life of its own. So if, say, for example, the state had charged the corporate body and then Moses would come in there, it would mean that evidence that is admissible against the corporate body would also be admissible against that director.
Yes.
Which is different in this scenario. Moses Mpofu is not being charged as a director of a corporate body. This is
what does that mean? How does he become different?
Okay.
You say when he's wearing his hat as a director, he's one Moses Mpofu. When he's wearing, what does personal liability mean?
Personal means you go to jail yourself. Even though the company cannot go to jail.
It is not an official capacity, isn't it?
Personal is not official capacity, my lord.
Yes. So
it's
why
not
do you keep saying if he's director? Personal means when you are not wearing your official capacity.
Yes. Yes, my lord. I am saying there's a reason why the Act mentions positions, my lord. There's a reason why the Act says director, employee, for example.
I see.
It's to give context to the effect that you are coming in that capacity as a director. But it's very different in these proceedings that we have before yourself, my lord. In these proceedings, the state is saying there is no corporate entity to talk about. It's non-existent. In fact, they are saying the offense that Mpofu did is to act on, is to misrepresent that there is a certain corporate entity which does not exist. So the state is not, in its view, even charging him as a director. They are saying it's non-existent. So once they do that,
So you're saying that
we cannot talk of the
private limited could not be charged with the same offense of using a non-existent entity.
With this, what I indicated, my lord, to say Black Deck itself, maybe if they were saying it used an unregistered trade name, it's different from saying
This is
a
the reason why I
non-existent.
keep referring to co-accused persons. I'm saying the state is saying, look, the non-corporate entity which was used is Black Deck Livestock, isn't it? And we are saying Black Deck Private Limited is a person. Are you saying it could not be charged with that offense as well? With using this non-registered entity?
My lord, I start off from a different perspective, because when we say non-registered entity, my lord, it's not non-registered entity. It's non-registered trade name.
No, I'm not saying the state is correct.
Yes,
We are simply saying, couldn't Black Deck Private Limited be charged with submitting a bid in the name of an unregistered company? Those are the state's thoughts. But was it not liable? Could it not be charged with that offense? Black Deck Private Limited itself, as a person, could it not be charged with that offense?
Yes, my lord, and I'm saying that offense, I'm assuming that the state is correct in its interpretation of section 29 of the Companies and Other Business Act. And then I'm saying, where the state is correct that they used an unregistered trade name, it does not amount to use of an unregistered entity. It does not create a new
We are
entity.
not even accepting that by the state. We haven't done that.
Yeah, we are not, but I'm
That is
assuming.
the state case.
Yes.
This which you are saying was not proved.
Yes.
Yes.
But I'm just going on an assumption that, say for example, the state has proven that.
Okay, now
And
I understand you.
Yes, and I'm saying even where the state proves that, say for example, they were charging Black Deck Private Limited, and they proved that it was using these trade names which were not registered. I'm saying in terms of that section, the offense will be the use of unregistered trade name, the use of unregistered alias. But it cannot be the offense of creating a new entity altogether. You cannot say there are three entities.
No,
This is what the state is saying.
I hear you.
There is one entity that is just using different acronyms, different names, but it's one entity. And that offense will be the unlawful use of a trade name, not an unknown or non-existent entity. Yes.
Obviously, you are saying they could have done that, they were not going to succeed. That should
Yes, even if they've done that, we're then going to say, look,
Yes.
section this says that.
Thank you.
Yes.
You can proceed.
Thank you, my lord. Now, I'll go further. In the state submissions, my lord, the state goes so very long to say the accused person sired children with Ajine, and they had 3 children, and they even started off from a note to say, you don't even remember the date of birth of your children and things like that. And they say that, my lord, as if criminal offenses are sexually transmitted, when they are not. The state must prove an offense in respect of an accused person, rather than to say, if you have a child with someone and that person commits an offense, therefore, and then you are liable. It does
Are you
not.
saying Kabisira committed an offense?
No, I'm saying even assuming that she committed an offense. Because this is what the state is saying, to say you want to throw her under the bus, but she's your wife, and you are also there for criminal libel simply because you had a relationship of a sexual nature. And I'm saying even if they prove, even if, say for example, there was an offense that was committed, she would be liable for that, so long as the accused person proves that I did not do this.
Okay.
Yes, my lord. I'll go further, my lord, and state that the state then puts a burden on the accused person to say, why did you not account? Why did you not do this? Why did you didn't account for what the monies was used for? You didn't do 1, 2, 3, 4, 5. And this is where the problem of what we have really been engaging on comes from. It's because they've simply charged Mpofu in his personal capacity. And he, in my respectful view, does not have an obligation to account for anything. We must start off from saying, once he proves that he did not make any representation to the state, once he proves that he did not make any representation to the state, and once the state does not prove any actors on his part, the case falls away. Yes, pardon me, my lord. I wanted really to follow you. I really believe I would benefit a lot from the engagement of the court. That's why.
No, I think you have already, assisted us a lot in interpreting. The reason why I engaged you on sections 277 is because they were not discussed.
Yes,
in
indeed,
the heads
my
of
lord.
argument.
Yes.
Otherwise, the rest we read.
Yes, my lord.
Maybe unless you want us to, under the summary of the state case.
Yes, my lord.
Are you there?
I will be there. Will you go to my lord? Yes, I'm now there, my lord.
What is the first sentence? First paragraph?
Sometime during the year 2021.
Summary. There's where there's a subheading summary.
Yes. Oh, okay. Accused one is Mpofu, a male adult aged 49 years, residing at stand number 5 Cambridge, Greendale, Harare. He is the managing director of Black Deck Private Limited. Yes.
What are the implications of that?
Okay. The implications of that, and I'm indebted, my lord. The implications of that is that if you look at it alone, is that they are saying Moses Mpofu is a managing director of Black Deck Private Limited. Mm-hmm. That is the implication of it when you look at it individually. Mm-hmm. I'd like, my lord, to go further, my lord, and say, in the charge sheet itself, you would then get the picture of what we are talking about, in the sense that that they indicated that the company does not exist.
Which company?
The Black Deck Livestock and Poultry.
But Black Deck Private Limited exists.
Yes, my lord. So they must then take a stand, my lord, like what I was saying, to say, does the company exist or not? If they say the company exists, then...
Well, that is a factual dispute which we are going to resolve.
Yes, my lord.
You are saying that Black Deck Livestock and Poultry exists because it is the same entity as Black Deck Private Limited.
Indeed.
So the state says, no, it doesn't exist because it was not registered in accordance with the law. That's a factual dispute which we are going to resolve.
Yes.
You see, and the way we resolve it is obviously going to impact on the outcome.
Indeed.
But we are not dealing with that.
Indeed.
I'm saying, so according to the state, there is one existent entity, which is Black Deck Private Limited. And there's another non-existent entity, which is blackjack livestock and poultry farming. Do you understand that to be the state case?
Well, my lord, it could be that
they may be correct, they may be wrong.
Yes, they may be correct.
But is that not the position that they've taken?
Maybe it is the position that they've taken, my lord. Okay. But if it is the position that they've taken, my lord, their own witnesses clarified this issue.
Yeah, very well. We
yes.
Don't try and fish the outcome because we have not discussed with the assessors. That we will deliberate on your submissions and then we'll come up with the resolution of those factual disputes. I can't weigh in.
No, I do understand. I'm just trying to implore you, my lord, so that you see things from our view.
No, I see your point. Yes.
I'm trying to implore to this honorable
court. I was just trying to find out where you are differing with the state.
Yes.
Is it that the state is saying even Black Deck Private Limited does not exist? Or it is saying Black Deck Private Limited exists and your client is a director, but the entity which does not exist is Black Deck Livestock Poultry Farming?
Yes.
That's what they're saying.
Yes, my lord.
Yes. But you are saying the court must find that in fact Black Deck Livestock and Poultry Farming exists. I mean, it exists in the eyes of the law?
Yes.
Because it is the trade name of Black Deck Private Limited.
Indeed.
So you are when you speak about this entity, I mean this name,
yes.
you're actually speaking about the registered entity.
Yes.
That is the position.
Yes. Yes.
Okay. We are
yes. And yes, my lord. I'm then going further to say that the state must make allegation based on evidence, and their own evidence from their own witness was to the effect that it's one and the same thing.
Yes, I accept.
Yes, my lord. So when the state then makes this, it just makes it as a reference to employment of some sort. When it says the first accused person is Mpofu. But when you look at it then totally, my lord, you would find that the corporate body, Black Deck Private Limited, is not being charged here. Or neither is he being charged in a representative capacity. Thank you very much for that, my lord. I now wanted to move on to a different issue altogether. I wanted to move to the issue of circumstantial evidence, my lord.
Yes.
To say that in answer to the requirement of the law that the state must prove actus reus, the state has said we are relying on circumstantial evidence. I would have expected the state, my lord, to then say these are the proven facts. And from these proven facts, they are pointing out to one outcome. And that outcome is that Moses Mpofu did this misrepresentation. That is what I would have expected it to be saying. But I submit that the state is not saying that.
Yes, thank you.
And when we are then dealing with it, the law then says this honorable court is not entitled to jettison and reject totally any explanation that an accused person gives in answer without it sifting through the evidence. And this is the explanation that Moses Mpofu gives. Because we must look at this issue from, there's an issue that my learned colleague related to, the issue of forgery itself. And we must understand that the accused person is not being charged with the offense of forgery in itself, of those two exhibits, right? And the offense is the misrepresentation, in my thinking, in my respectful view, is that they are saying that let us forget who did it, whether it's Black Deck Private Limited or Moses. They are saying that the misrepresentation is one person going with a bid document and saying this company is compliant. It is a NASA certificate, it is a ZIMRA certificate. When you know, or you ought to have known, that it is not compliant. That is what constitutes the misrepresentation. Now that we've put aside the issue of whether or not the company is registered, is existent or non-existent. So if that were the case, and the accused person then says this in his explanation of why he thought that the company was compliant, he says, when we were meeting in our board of directors, I was seeing reports that we are compliant. I was seeing reports that we had paid. I was seeing reports that we had engaged a third person, and I believed that to be correct. This is not my field. This is not my department. There's someone who is responsible for that aspect. That explanation is reasonable, my lord. That explanation cannot, in my respectful view, just be jettisoned. You
are saying you are agreeing that the use of a false document constitutes fraud.
The use of a false document, yes, my lord. Yes.
So you are just urging us to accept his explanation.
Yes, my lord. Okay. Yes, my lord. I'm saying if someone intentionally uses a false document, say for example, if those documents, but I'm not admitting that those documents were false, my lord. Okay. I'm not admitting that the documents were false, but I'm saying even assuming that the documents were false, and the accused person comes with an explanation, and the law says this: if the explanation is reasonable, and especially in a matter where the state is relying on circumstantial evidence, it cannot just jettison it as an outright false or an unbelievable story. Okay. Which is what the accused person managed to establish in my respectful view when he was then giving evidence and explaining. I will go further, my lord, to say, if indeed we assume that those documents were false, the state would then in that scenario be supposed to establish the perpetrator, as it were. If, say for example, Chimombe forged the documents and then placed them in a tender document and then submitted it to the ministry, the state must then have established that the co-principal offender is this one, but he was acting in common purpose with Mpofu for criminal liability to visit Mpofu. In other words, there must be an allegation of common purpose with the principal offender. So once the state does not allege common purpose with anyone, they are actually alleging. The
principal offender be, what name did you mention?
I used Chimombe as an example.
Just as an example.
Yes, my lord.
We are not implying that he is a...
No, I'm not implying that.
Assuming that, would he be the principal perpetrator or the company that he represented would be the principal perpetrator?
Yes, thank you very much, my lord. The company will be the principal perpetrator. Okay. If say for example the whole company knew and the whole company met and resolved, let us forge these documents. Let us put them.
Is there any doubt from the accused's perspective that the company resolved to submit this bid?
No, the company resolved to submit the bid, my lord. But I'm talking about the aspect of forgery of the two documents. Okay. Yes, my lord. Yes, and I am saying the explanation being given by the accused person as to where did these documents come from. Because there is the aspect of misrepresentation to say where you are aware that there is a risk of that information then turning out to be false. So I'm saying in that scenario, one must then look at the explanation that is being given. And Mpofu is saying, in his view, in his right mind, he was of the view that the company was up to date because he saw it in reports. Yes. I just wanted to deal with just a few other aspects. There is also one other aspect that I want to deal with, my lord, that the state did not call the investigating officer in this particular case, and the effect of that. My lord, you see that from the exchanges that were had with the court, that there are a lot of questions. And my brother cannot lead evidence from the bar. From all his witnesses and all the exhibits that were produced, none of them is actually saying Mpofu defrauded us. There's been no complaint. The investigating officer ought to have taken the stand. And if he had taken the stand, he would have really clarified and explained onto all these issues, because the responsibility still lies with the state to prove its case beyond any reasonable doubt. And the IO should then have explained all these particular aspects. And the state's cases crumbled by the failure to call the investigating officer to come and piece the relationship between the law, as it were, and the facts that were there. That is the other submission that I wanted to make. My lord, I believe with that I would abide by the other submissions that we have made, and I would ask my brother to just emphasize. I may have missed some other.
Yeah, but
aspect.
maybe just one thing before you take your seat.
Yes, my lord.
Was there, were the supporting documents of any significance at all?
The supporting documents of
which were required by the tender?
Oh yes, yes, they were very significant, my lord.
Tell us about them.
Right. They were very significant in the sense that those supporting documents would really, as it were, motivate.
Maybe let's take them one by one.
Yes, my lord.
The certificate of incorporation?
Yes.
What was its purpose?
The certificate of incorporation was to show that the company is indeed a registered company. Because the tender, one of the witnesses testified that it was a tender that was only open to corporate personnel. It was not a tender that was open to,
so it was to prove
private
that
person.
The bidder is a corporate entity.
Yes, yes, indeed.
Which other document was required by the way? The CR6?
Yes, CR6, CR6, CR14.
What was its purpose?
The same, my lord. to show that the company is indeed a registered company.
Is that what it speaks to? Is that what it speaks to?
It also...
The certificate of incorporation is certifying incorporation.
Yes.
Literally, that is what it is saying.
Yes, my lord.
And CR6, what does it speak to?
The CR6, that's the document that was the old CR14.
I'm not sure. Let me see. I could be wrong. Let's look at the requirements together. I'm not sure. Where are the requirements? There's a document that you...
The CR6, my lord, I don't know which page number it is, but it shows the address.
The standard bidding document is the one I'm referring to.
Yeah.
It lists the documents that would be required.
Yes.
Yes, there's what is called a CR6.
Yes.
What purpose does it serve?
Address, my lord. It certifies
of
the address of the company, of the corporate person.
It certifies what?
The address. My lord, there's a document that is the CR6 that is there.
Yes.
Which says to the registrar,
what does it say?
The above mentioned company hereby gives you notice that the registered office principal's place of business of the company is this.
So it identifies the principal office.
Yes.
And it must be correct.
Yes, my lord.
Okay.
Yes.
CR14?
The CR14 gives the details of the directors of the company. And who the secretary is.
So what address appears on the CR6?
The address that appears on the CR6, my lord, is 6A Otilia Close, Avonde Harare.
6A Otilia Close?
Yes, my lord.
Is that the address that was used in the bidding?
If you could just bear with me, my lord. I'm trying to identify.
Maybe you can start from the introductory, the letter that introduced the bid.
If you could just bear with me, my lord. My lord, there is a document, I don't know if it's the one that you are relating to, which is page 12.
I'm talking to the letter, about the letter signed by Tish Dembo. It is the one that introduced the...
Yes. This page. Second page. Yes. On this page...
is that the address that appears there?
No, it's not, my lord. The address that appears here is plot 10, Colenso Farm, Rimba District, Marsh West, Zimbabwe.
So do the addresses tally?
No, the addresses do not tally, my lord. They do not tally. And I believe, my lord, off my feet, that this is maybe what the accused person was relating to when he was explaining where the trade name Colenso came from, because he indicated in evidence that he was given an offer letter in respect of Colenso Farm, and this is where they were doing their farming.
Yeah, we had that explanation, but does the CR14 represent the correct position on the of the bidder, whoever the bidder was? Does it really reflect the correct position?
The CR6?
Yes. Because we know that the bidder official address is plot 10. The CR6 says it's 6A Otilia. Are we speaking about the same bidder?
I would say so, my lord. I'm also being minded that on the very first page, my lord, of that same document, you had referred me to page number 2 of the bid.
Yes.
Yes, it says number 6, Carson Close, Grindewara.
Yes, which is actually a different address as well.
Which is the same address, I believe, with the one on the CR6.
Oh, I heard you saying Otilia. What did you say? I wasn't looking at it. It's exhibit number?
Could just be with me again. Maybe I could be wrong, my lord. I'm just trying to... If you could bear with me, my lord, I could go and just consult my client. I see him.
Very well, I will allow you to talk to him, but just tell me
The CRS.
You were reading from some CRS somewhere.
Yes.
It's exhibit what?
It is attached after in that document. The document, the bid document. You would find that after there's a bid security of spoke, there is other documents, then it is annexure number 3, I believe, to that bidding document.
Exhibit should be exhibit 12. Let's look at it. So that we get things right. Yes, it says 6A Otilias,
Yes, my lord.
which you read.
Yes.
So it's also different from the address which is at the top.
At the top,
on
number
the
6,
face
custom close. Yeah.
Yes, on the face of the bid itself.
Yes, my lord.
So we are talking about the same entity?
Well, I wanted to just consult my client maybe before I answer that.
No, you are addressing the evidence. Which is before you. I'm sure you can answer that question without referring to your client. You may have an explanation for that, but we are way past that.
Yes, my lord. I'm saying this because this line of argument, this line of addresses was not covered in the trial. To say the address that is, I may have missed it, but in
no,
my
you took us through every page of that bid.
I did.
And so we were looking and seeing those addresses. I'm just asking you to explain whether the addresses tally.
Yes, my lord, but I'm saying that fact of whether or not the addresses tally was not laid in evidence.
On the face of it, it's a factual thing.
Yes, this is why now
Are you about to say 6 Otilia A-Roti is the same thing as Castle Road?
I do not. This is why I was saying maybe if I just could be indulged 2 minutes.
But then you would be giving evidence.
I'm trying not to give evidence, my lord. Myself, I'm trying not to give because I do not know.
Maybe I should hear from the state. State, he wants to talk to his client to be able to address this issue.
These are addresses on evidence before the court. Then the accused person cannot, unless he is, unless he wants to, what my learned colleague intends to do is tantamount to asking the accused person to address the court. Because he cannot seek an explanation which is not on record. If it is not on record, it means that that is new evidence which cannot be adduced at this moment. Yes. Otherwise, all the evidence that he is summarizing on should be found on record, and therefore there's no need for him to seek a factual clarifications or point of law. At this stage, it's a matter of assisting the court in on the evidence that has been adduced.
Thank you.
Yes.
Well, the consensus is that we cannot allow you to do so.
Thank you very much, my lord. Thank you very much, my lord. So, my lord, my submission in response to this honorable court, my lord, is that the issue of the addresses, whether or not it is being tallying, is one that is being raised meromoto by the court in my exchange. And it is an issue that the state, neither of the parties put that aspect to the witnesses. Neither of the parties put that to the witnesses, and it then, in my respectful view, amounts into getting evidence from the bar. And with respect, my lord, I would submit that I cannot take my argument as far as whether or not the addresses are tallying any further than that, my lord.
The CR14?
The CR14, my lord, relates to the directors. Yes, my
And
lord.
what is the significance of that?
The significance of that, I believe, my lord, is to notify that this is a genuine company. These documents were filed and stamped by the registrar of companies.
Well, that's its purpose.
Yes, it is.
Not
it is
to
noticed
inform,
to
not,
the.
not to, it is not, isn't it its purpose to disclose the directors of the company?
As at the date that it is filed, yes, my lord.
Why are you even anticipating that?
No,
Okay,
I'm
very well.
only saying it, my lord,
Naturally,
maybe
at
to.
at the date, and if
I'm-
it is being submitted, what is its purpose?
Yes,
At the time that it is being submitted, what purpose is it serving?
yes, it is giving notice to say the company, the bid document required the company to submit certain documents,
Yes.
which we have been going through one by one. The purpose of having those documents submitted would be, in my respectful view, to substantiate that this is a genuine registered company.
Not to disclose the names of the directors.
Yeah, it does disclose also the names of the directors. The reason why maybe, my lord, you were relating to the aspect that I was trying to anticipate something was premised on the submission, my lord, that relates to the issue of the company documents, that some of the aspects of a company are held by the company secretary. You would find that the company documents would relate to the secretary of the company. So a company may change from what it exists in a certain document, but the secretary would be aware. Say, for example, the shareholding and everything of that nature.
Okay. Did
Yes.
the CR14 correctly reflect the directors of the bidder? Assuming, as you say, it was Black Tech Private Limited.
I believe it did, my lord.
It did,
Yes.
fully.
Well, not fully, as at the date that it was lodged, my lord.
No, yes,
The-
with the
um,
date, that is the date which concerns us. The
Yes, my
date when
lord.
it was submitted with the bid, was it correctly reflecting the situation on the ground, as you know it?
No, my lord. Why I say that, my lord? If a document says submit this document, and you're submitting a document that is required to be submitted,
Yes.
yes. So if the bid said submit a CR14, you submit a CR14.
Just like
As
without serving any purpose.
as it is. But then maybe in the bid document itself, my lord, you would then explain other things. You would find, for example, my lord, the issue relating to Colenso Farm. You would find that amongst the documents that were submitted, they were motivating and indicating that these goats, some of the we have experience in goat breeding because we do this at Colenso Farm. And there were even pictures of that goat
You're probably
rearing.
trying to figure out why I'm asking that question and you are anticipating. I'm simply asking, did the CR14 correctly reflect the directorship of the company, if that is the correct word? By directorship, I'm trying to find the correct word for the people who were directors of the bidder.
Yes. For lack of a better word, my lord, the CR14 was not an updated version of what the
So
client...
it was not correctly reflecting the persons who were directors.
To the extent that it left out Teach Dembo, to the extent that it left out...
Is it important that in a bidding process, directors of the bidder should be known?
One would expect that, my lord.
Why?
One would expect that because...
Why?
Because they must know, for example, who are the representative of the companies, because it cannot be anyone can then come and talk to the ministry, for example, on behalf of the company.
Not anyone can come and talk. Is it not that the directors are also vetted?
I do not know, my lord. I do not. I do not know, my lord.
You don't know.
I would not
But
want
anyway,
to hazard an answer
the
to that.
ministry required information, correct information on the directors.
One would obviously expect that, my lord. Yes.
So there was a duty to disclose. There was a duty to speak, isn't it?
Yes, my lord.
Was that satisfied?
Well, my lord, I believe it was. I would want to make this submission, my lord, that the state has not alleged, for example,
I
that
haven't said we are coming to that. We are just dealing with the facts. Maybe I'll come to the significance later, but I'm simply saying, to that extent, is it correct that there was a duty to speak on the part of the bidder?
Yes, my lord. I'm just trying to give a Picasso to my answer,
Yes.
so that the extent of what I answer is then properly understood in context, because context gives everything, my lord. The accused persons are not facing, the first accused person is not facing a charge of misrepresenting in a bid document to say these are the directors, but these were not the directors. And I give that answer in that context.
Okay, in that context, yes.
To say one would expect ordinarily that you must, because in fact in terms of the law, when you are dealing with public officials, you have a duty of disclosure. You must disclose. That is what the law requires. Yes. And if one then fails to do that,
Yes.
one can then be charged to say you were supposed to do this, you didn't do this.
That is if the state comes to know that there was non-disclosure, isn't it?
Yes. For example, the
And
state
if at
could
the
have.
time of commencing the proceedings, the state was not aware of that.
If it was not aware of that, and then it comes alive during the proceedings,
Yes.
the state is at will to apply to amend its charge, if it wants to amend the charge, or the state is at
So
liberty
you are accepting that
to charge.
there was a non-disclosure, but it doesn't form part of the charge.
I'm not accepting, my lord.
So what are you saying?
I'm simply saying, my lord, I cannot really answer that because they are not being charged.
Okay,
On my feet, I cannot say there was disclosure or non-disclosure.
Okay.
I can't. Yeah.
Which was the other document?
Of
The
course,
tax
there
clearance.
was these two documents, the tax clearance
tax
and the NAS.
clearance,
Yes.
And you are saying that Black Deck Private Limited was tax compliant?
No, I'm not saying that. I am saying Mpofu genuinely believed that Black Deck Private Limited was tax compliant. He has not, from the time that he was arrested to date, he explained on his stand that he had not had an opportunity to then verify whether or not it was tax compliant.
Those are all the questions we had for you.
Okay, my lord.
Maybe Mr. Koto, you still want to add something?
Yeah, just a few, maybe. Just a comment on the meaning of section 277 of the Criminal Codification. My understanding is that the law is saying any conduct by an employee, by a director, or any other person in pursuit of a company's business, if it amounts to a criminal offense, that criminal offense attaches to the company. Then once it does that, there is then a presumption that every director and every employee is also criminally liable. However, those employees and directors can rebut that presumption on a preponderance of probabilities by showing that they were not actively involved in the commission of the offense. So the starting point is that no one else is liable for a company's offense. It is the company itself. Then the directors and employees can then be screened to find out who was involved and who was not involved. Now, in this case, what seems to have happened is that the state, with all due respect, appeared to have used some method like spinning a coin to find out who to charge. Because exactly there is no basis, factual basis, for connecting Mpofu to whatever is complained of. Why I say so?
So, Mr. Koto, were you aware of Section 277?
Yes.
Did you address it in your closing submission?
I saw that there was an omission, but if you remember in the application for discharge, I actually argued on Section 277. Yes.
So you abide by that?
Yes, I abide by the position that it is the company and no one else. So in this case,
So liability starts with who? Between its employee and the company itself. Liability starts with who?
it starts with the company. That is, liability attaches to the company. Then once it attaches to the company, there is this presumption now.
What you accept that by and large, Section 277 is a codification of the concept of vicarious liability.
Exactly.
In as much as, you know, how we are just being told how it applies in criminal law. So how does vicarious liability work? When you use it in civil, well, how does it work? Who starts with liability? Is it the company or the person?
Well, in a civil setting, if the perpetrator is liable, then the principal. It's the other way around.
Yes, the perpetrator, an employee does something.
Yes.
And then transmits liability to the employer. If he's working within
yes,
the scope of his employment and
yes.
furthering.
Yes.
So it starts with who?
With the employee, the perpetrator. Let's take for instance.
So why are you saying now the intention was to start with the company?
Because it says any, let me read it. For the purpose, that is something true. For the purpose of imposing criminal liability upon a corporate body.
Leave that. We are not dealing with the corporate body. We want to deal with the person.
No.
How does a person...
It says, any conduct on the part of a director or employee shall be deemed to have been the conduct of the corporate body.
That's exactly what the vicarious liability is all about.
Yes.
So it starts with who? If just confining yourself to what you have read,
yes.
It starts with who? Does it start with the company or with the director concerned?
To the extent that it is saying any conduct
Yes.
in pursuit of a company's business
Yes.
shall be deemed to be
Yes.
that of the company.
Yes.
My understanding
So
is that
who is doing the acts and the omissions?
it could be an employee, it could be a director, but then Section 277 is wide. It says even outsiders who perform in pursuit of the company's business. Otherwise, ordinarily, outsiders would not, the acts of outsiders would not attach liability to the company.
Thank you. Anything else?
So, you have been said that the position I'm saying is this case was presented and fought on the basis that Moses Mpofu, from the summary of evidence, I'm quite aware that he is not facing a charge of forgery. But from paragraph 3 of the summary of evidence, the case is presented on the basis that he is the one who forged. If he forged, then he knew that it was not authentic. Then he forged with intention of attaching it to his bid, not to Blackjack Private Limited bid. He was attaching it to his bid in respect of a non-registered company. Now, the moment we now want to come back to say, now they are directors, already we are saying we are departing from the earlier position that there was a non-existent company. Because a non-existent company cannot have directors. So the moment now we depart from that position, it means the basis upon which the case was presented and fought has now changed. It becomes a new charge now. The factual
So does a company known as Black Dick with only 2 directors exist?
with only 2 directors? No, it exists with 3 directors, not with only 2
So
directors.
does the company which submitted this bid exist? Because the company which submitted the bid purports to have 2 directors. So is it the same company that is Black Dick Private Limited?
Yes, my lord. You take judicial notice of the fact that they are what we call annual returns.
Oh, I see.
Yes. So the company secretary is obliged to make annual returns. Now, what we have here are the documents that were generated back then in 2015.
I think Mr. Jetiri has already covered it.
Yes.
Is
So we are
anything
saying there's not been any updates. Now, on the issue of, to emphasize why I'm saying most important ought not to have been charged, we are saying the certification and declarations that ought to be considered to be false statements were made in the bid by a person who signed for them, and that person is not Muslim. Now, once the state noted that there was a person who was making representation to say, we as Black Dick Private Limited, we have complied with all the requirements as per your tender, requirements. We have attached our NASA compliance, our tax clearance certificate. This is the address. That person is the one who made the representations. The question then becomes, were those representations true? And were they made with a criminal intent? If they were made with a criminal intent, that person, together with the company, are the ones who are liable. That's why there is this proviso under section 277 to say, provided if an employee or director proves that he was not actively involved, he shall not be liable.
I see.
Yes. Now, still on the issue of the authenticity of the tax clearance and the NASA certificate, there is another problem that from the evidence yet, we have not been told that the documents that were taken for verification were plugged from Black Dick Private Limited's bid document. Why we are saying so, there was a position that there is no company to talk of. Now, there is no guarantee that the state has been denied the existence of a company. Then they took those documents from a registered company's bid. The witnesses who came to testify in court did not say they saw where the investigating officer plugged the documents from. When the accused persons were arrested, they testified in this court that they were not told where those documents were taken from. That aspect could only be cured by calling the investigating officer to tell the court where he got the documents that he took for verification. After doing that, he was then supposed to go to Black Dick to say, are these your documents? Black Dick was going to either deny or accept those documents. Now, if this court is to proceed on the basis that Exhibit 1 and 2 was taken from Exhibit 14, then with all due respect, it will be acting on the basis of speculation because no evidence has been laid on that aspect. We do not know where they were taken from. So because of that, there is no evidence that these documents are a forgery.
Okay, thank you. Anything else?
Then, on the aspect of accused number 1, he has been aware, as my colleague for the state wants to put it, that he ought to have been aware that these were forgery. Again, it has not been alleged by Well, he alleged that his operations are in the bush, right? So he has nothing to do with what happens in the office. The state has not been able to rebut that. In fact, from the whole state defense outline, as captured even in the state closing submission, everything that the accused person said has not been proved to be false. So because of that, it cannot be said then that the state has proved its case beyond any reasonable doubt, especially given that it has now abandoned the allegation that it is accused person who forged. It seems to have abandoned the allegation that he presented the document to the ministry. In any case, there's no way the state could maintain that stance because evidence is proved from the state witnesses that he did not communicate that document. So Section 18 of the code then places a burden on the state to prove each and every element of fraud. So having failed to prove the first critical aspect, that is statement by the accused person, because the only statement that we have in Exhibit 15 are the ones coming from one chairman and not accused person. So the moment the state fails to prove uttering of a statement by the first accused person, that's where the case collapses and accused will be entitled to his acquittal. Those are my submissions.
Thank you. Just before you sit down, just one last question. Why were the defense witnesses who were mentioned not called?
Well, the defense witnesses were not called because, as I said, this matter had been presented and fought on the basis that it is accused one who forged and then presented the documents, well knowing that they were forgeries. Now, when it was discovered now from the state witnesses that, maybe before that,
so maybe it's just it was a deliberate decision that was made.
Yes.
Oh, okay.
Well, his focus was to prove to the court that no, it's not me. It is a company code, like the private limited. So when it was then noticed, coming from the state witnesses, that the state now accepts that the company does exist, they need to call those witnesses to come and prove that they are coming from the private limited. They are employees of the private limited. False away, because it's already an accepted position. You would note from the submission by the state at close of state case that it has already shifted. It had already shifted from the earlier.
No, I understand. I just wanted to understand whether it was because they were not available or it was deliberate. If it was deliberate, that's fine. Is there anything else you want to say, Mr. Kuta?
Well, maybe just to answer that, my lord. Maybe my brother was not aware. The reason, my lord, is because, number one, it was now impossible to call one of the witnesses, Kundai Bwanya, because he's normal. And number two, in respect of Ajine Kabisira, we made attempts to reach to her. I understand my instructing councils did, and they could not get her. And we still felt that with the evidence that was there, it was sufficient.
Well, maybe you rest your submissions?
On that note, I just wanted to clarify, because
yes,
my brother had not been
thank you.
involved in trying to...
Yes, Mr. Maduko.
Okay.
Okay, thank you, Mr. Maduko.
Thank you, my lords and learned assessors. We are going to be very brief. We will abide by our written submissions. We believe we've made a case there. What we'll do is that we'll make 4 points, and I will number the points. We'll make 4 points. The first point we make is what appears to be common cause, that the nature of the offense that is alleged in respect of our client is quite straightforward. The actus reus is that he is alleged to have made a misrepresentation by submitting tender documents belonging to a company that is known as Black Deck poultry and farming, that the misrepresentation was contained in a tender document. That is the nature of it. And then the misrepresentation is indicated that that company is registered, that the document relating to Zimra was genuine, and also that the document relating to NASA was genuine. We respectively submit that the state case must rise and fall on the basis of that misrepresentation, that the state cannot seek, as we tend to assume is what Mr. Mabawado was trying to do, to come up with other things. That is what the second accused need to answer. Did he make that misrepresentation? That's our point number one. We wanted to be clear on that. Then our point number two is that there was no direct evidence of any nature that linked the second accused to that misrepresentation. In other words, no evidence whatsoever to say that he could have been a person who submitted a tender on behalf of Black Deck, a person who participated in compiling that document, a person. It's clear there was no direct evidence. That's our point number two. And this point is admitted by the state. That admission is quite clear right from the presentation. And then if one wants to see the evidence, in paragraph 62 of their submissions, which are filed of record, they admit that they had no direct evidence. That takes us to point number three. Point number three is whether or not the state put before circumstantial evidence from which an inference can be drawn that the second accused did the misrepresentation. That's the point. Was there any circumstantial evidence that the state produced? Again, the answer is no. In fact, a very big no. We put a big no with respect, my Lord and learned assessors, because when one listens to my learned friend for the state, Mr. Mabawado, you get the impression that he did a lot of work in respect of the second accused. That's the impression you get. And he was even wanting to boast that he has put, substantial submissions. It's a long document. But there's nothing on the second accused which would amount to circumstantial, because that circumstantial evidence must relate to events before the tendering of the document. We must see facts that relate to the participation or activities of the second accused, from which we'll say, from these facts, the only inference we can draw is that this person submitted the tender. Nothing. Now he relies on events after, and then wants to do something that I have never come across. We must then read backwards. I think that's how we should do. We get some events, and then we read backwards and say, this kind of behavior shows that this person. I mean, that is impossible. I'm saying so, my Lord and learned assessors, from the one point that is known by everyone. Circumstantial evidence is based on logic. It's actually a principle of logic. And it would be logical for him to do so. We have said there, we've listed the activities that he would say. So he has nothing prior to the submission of the tender, totally nothing. And any circumstantial evidence would have to relate to that. But if we take it, let's take the view that perhaps such a thing can exist. That you look at events that happen and then you want to draw backwards and say that. My Lord and Lady assessors, the events that he's referring to would not, whatever way one would want to stretch them, be said to be facts that would be circumstantial. We give examples that are listed in his paragraph 62. The first one, he claims that there was a meeting with Mindurwa. Ms. Mindurwa said he met the accused person after the event. Then the second, he says that Mr. Jiri, Professor Jiri, Obed Jiri, did make references to meetings with the second accused. Fourthly, he makes reference to the fact that there was a meeting, which we admit the meeting that is minuted is on record. Then the fourth thing, he refers to the transfer of money from Black Deck to Miltech. He made a lot of noise about that even when he was present. Let's just take those four events. We all accept that these are events after the commission of offense, because this offense by law is frozen. It takes place at a particular place. You make a misrepresentation, the misrepresentation, you do it with an intention that it be acted upon. It is acted upon to the prejudice of the person who has acted upon it. Those things happened by the awarding of the tender to Blackburn. At least that is what the offense is. Now you have events that will happen there. You cannot read into them the fact that because he met Mindurwa, that meant that he must have submitted the tender. You can't say that. Or because he had a meeting and he discussed, he showed an interest. I'm sure there would be so many people who would have shown an interest in this tender, although of course they were not placed before the court. But that sort of reasoning is not accepted by the rules of circumstantial evidence. Right?
It's not permitted.
It's not permitted. You cannot do that and infer and make an inference of that nature. So there are no facts. Those would not constitute facts for circumstantial evidence. But my Lord and Lady says that you would have found that in our submissions, we took some effort and we did that out of abundance of caution. We even then poked holes into that. The meeting with Mr. Mindurwa, we challenged that and we would say if it were to be relevant, but it shouldn't be relevant. But we did poke holes into it. Our client denies ever meeting him, and we raised that in cross-examination. Professor Jiri actually abandoned his earlier position under cross-examination. He started speculating, said, well, I'm no longer sure whether it was the second accused or another Chimombe. And then the meeting at the ministry, which is minuted, clearly that took place, but there was also no participation that is evident from the meeting by the accused person, the second accused person. Then we have the transfer of money. There was no doubt that there was a subcontracting to Milton. We are saying that even if one were to do that, but I think the better position, and then of course the permanent secretary, you will remember my Lord and Lady assessors, that he then said that the second accused had a spiritual connection. That's what he said. In fact, he said something close to that. He says, and so on. So at the end, we would say that with our third point, my Lord and Lady assessors, even if we were to rely on circumstantial evidence, it cannot be done. Then finally, I said the fourth point. The fourth point is a very worrying submission made by my learned friend. You see it also scattered in his protocol, and then he is very fond of that case, and I will call that fourth point the Tembo Tombe scenario. That case, my Lord and my learned assessor, does not apply. Do not apply in this situation. It will not apply at all. I have then taken the liberty to then open that case. I will just illustrate the point. He is correct that I did my best at the Supreme Court to try and make my point. But that was in a different scenario. The Tombe case relates to a trial in terms of section 196A of the Criminal Code, which is the co-perpetrators. That's the position. And that for Tombe to apply, you must first find mens rea. You say that these people, because that was the issue, you find mens rea first and foremost, that these people intended to commit an offense. And it's obligatory that you find it upfront, ahead. Once you find that they have a common mens rea to commit an offense, you call them co-perpetrators. So whatever they do, the actus reus of one becomes the actus reus of the other. That is the law, and that is what Tombe stands for. It cannot apply in situations of this nature. It's clear. It says that if two or more persons are accused of committing a crime, and the state adduces evidence to show that each of them had the requisite mens rea to commit the offense. So your starting point is you prove mens rea, and you say that they had the mens rea. In other words, they come together to say, we want to do this. Once you find that that is what they agreed to do, then it matters not who does what, who phones who actually makes what statement, and so on. So I'm saying this, my lords and my learned assessors, because I think the state, I'm not sure whether he was saying so, genuinely misunderstanding that case. But it is so obvious that that case cannot apply here. There was never an attempt, the trial was never proceeding on the basis that the second accused was an associate. He was a principal. in terms of what is before the court. It would have been very different had the state proceeded on the basis that we accept that you didn't do this, but you are associated with the first accused. That was not the case. But during the time he is then making his submissions, he is then trying to say, well, it's by association. So the association aspect arising from the Chimombe scenario does not apply. And even if one were to want to apply it, what sort of association would lead to a situation such as this, that you attended a launch meeting of this boat scheme, therefore you submitted a tender? That can't be. You received money sometime late, and that should be a different crime. If it's a different crime that he wants to prove, let them do that. But certainly on the facts of this case and the trial, the way it proceeded, my lords and learned assessors, there is simply no reason, no basis whatsoever to link the second accused to this offense. Those were our submissions, my lord.
Yes, very clear. But I just want to understand just one question. You are saying it never happens that you can infer commission of crime or involvement from subsequent events. Is that entirely correct?
It would not be entirely correct. I think I'm not saying that. It is not entirely correct.
Yes.
You would have to set the facts, and then you say these are the facts which are subsequent. And that those facts which are subsequent, the only inference, the only reasonable inference you can draw from those subsequent events.
So
is that this.
I thought the position would be, yes, certain inferences can be made from subsequent events.
Yes.
But would they be the only inferences? Because I was wondering whether, in fact, a person found wearing a stolen shirt would be charged with theft, because that's a subsequent, something that being discovered after the offense has been committed.
Yeah.
And then now you want to infer backwards, which you said should never happen. You can.
Well,
you can now reason backwards. Tell us, where did you get this shirt? If you don't give us a reasonable explanation, you are the thief. So it can be done. But if the question is the sufficiency of does it meet the criterion that was set in was it the Bloom case?
Yes,
the Bloom case.
So, thank you, my lord. I have no problems. I entirely, with respect, accept that.
Yes.
I think what I was doing was to clearly, or with passion, say that all the facts of this case, you can never say that what my friend has put across can lead to the only reasonable inference being that the second accused did submit a tender. That's what our submission.
Yes, as I said, your position is very clear. We don't need to interact with you. Thank you. What then should happen? Any responses on the law?
None, my lord.
How is our Wednesday next week registrar? It's free. What would the date be? 22. Council, can you consider the 22nd?
It appears from the defense bar we are comfortable with that date, my lord.
Unfortunately, my lord, the whole of MPA will be having strategic meeting in Lawan. The state may proposes the 27th.
The week after next.
Yes, from the 19th, this weekend, from the 19th to the 26th, the strategic meeting for everyone in the MPA. Maybe Monday, 22nd.
So the earliest date, according to the state, would be the 27th.
27th, yes.
Mr. Chitero, are you available on the 27th?
I had a Blawayo matter set down. I got Blawayo matter.
It's just not in judgment. Can Mr. Koto do that?
I was actually suggesting that to my learned colleague that
Mr.
if
Koto
it's
could
not
not
in, no, I mean in respect of the 22nd. I wanted to suggest that if the state could have someone who could just note the judgment.
Mr. Mabaudi?
If we may weigh in, my lord and learned assessors, I think it would be appropriate if the court is in a position to give judgment on the 22nd. Let that judgment then be handed down. My learned friend could send someone, because there will be, the course will be operating with NPS as far as we are aware. Someone could note judgment, then depending on the outcome, whatever happens.
It will be a written judgment anyway.
Yes.
There won't be any submissions. Will just be. It did be in a civil matter. It was just a question of reading the operative part. But because it is a judgment at a trial, we then read it in an open court. I don't see how your absence.
Maybe I was suggesting maybe is it not if it's Tuesday, it's not possible Monday or Friday of that week. You can possibly delay or come back in.
Sorry. You mean the 22nd?
Yes, either.
22nd is the
I was maybe proposing if you
Friday. What shall the date be on Friday? 17th.
this
Friday.
Friday.
This Friday is the 17th.
Yes.
Then Saturday 18th, 19th, 20th.
20 is fine.
20 is fine.
20 is fine for us. Yes.
Monday.
Yes.
Yes, one member will not be here. What about
The 21st.
21st? Oh, that's appeals day. So 22nd.
I think 22nd we will send someone if it is a written or written.
Yeah, it will certainly be a written judgment. I will just be reading from a written
That
judgment.
will be fine, my lord. There will be someone to be for the state.
Stand up accused persons. Come back for judgment on the 22nd of October this year.
Pardon me, my lord, maybe if you could have the benefit of the time.
Yes. What time is convenient?
Today we started at 12. But we're in the court sense from end time from 10.
1000 hours.
1000 hours. Thank you.
Any other business registrar? The court will rise.